Missouri is a state that takes a notably different approach to habitability than most of the country. And if you're a landlord here, understanding that difference is critical to managing your risk. Here's the big thing you need to know. Missouri does not have a comprehensive statewide residential landlord-tenant act. Unlike the majority of states that adopted some version of the Uniform Residential Landlord and Tenant Act, Missouri never did. That means habitability law in Missouri is shaped primarily by common law, local municipal codes, and a handful of scattered state statutes. Missouri courts have recognized the implied warranty of habitability, but the protections are more limited than what you'd find in heavily regulated states. The general standard is that landlords must provide a dwelling that is reasonably fit for human habitation at the time the tenant moves in and maintain it in that condition throughout the tenancy. That covers the basics: sound structure, working plumbing, functional electrical systems, adequate heating, and freedom from serious health and safety hazards. Now here's where Missouri gets really location dependent. Because the state lacks a comprehensive statute, the real regulatory action happens at the municipal level. Kansas City and St. Louis both have their own detailed housing codes with inspection and enforcement mechanisms. Kansas City's code requires landlords to obtain rental licenses and pass periodic inspections. St. Louis has a similar system with its own building inspection division that actively enforces local housing standards. But if your property is in a rural area or a smaller town without a local housing code, the regulatory framework is much thinner. You're still bound by the implied warranty of habitability under common law, but there may be no local inspection process or code enforcement office to deal with. That doesn't mean you can ignore maintenance. It just means the enforcement mechanism shifts to the courts rather than administrative agencies. When it comes to tenant remedies, Missouri offers some options, but they're not as robust as in more tenant-protective states. Tenants can pursue claims for breach of the implied warranty of habitability in court and seek damages. They can argue constructive eviction if conditions are severe enough that the property is essentially unlivable. And they can contact local code enforcement in municipalities that have inspection systems. Missouri does not have a statewide rent withholding statute. However, and this is important, the City of Kansas City does allow rent escrow under its local tenant protection ordinance. Tenants in Kansas City can deposit rent with the court if the landlord fails to correct code violations after proper notice. This remedy is specific to Kansas City and doesn't apply statewide. Missouri also lacks a statutory repair and deduct remedy at the state level. Tenants generally cannot make repairs and deduct the cost from rent unless a local ordinance specifically allows it. One area where Missouri has gotten more active is lead paint regulation. Properties in St. Louis and Kansas City built before 1978 are subject to local lead paint ordinances that go beyond federal disclosure requirements. Landlords in those cities should be aware of additional inspection, testing, and remediation obligations. Missouri's anti-retaliation protections exist, but are limited. There is no broad statewide anti-retaliation statute. Some municipalities have their own retaliation protections, so again, local rules matter. The bottom line for Missouri landlords: where your property is located makes an enormous difference in your regulatory obligations. Make sure you know not just the state-level standards, but the specific municipal codes that apply to your property. For the complete guide to Missouri's habitability landscape, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.